Hi everyone. As you will likely be aware, the legislation which facilitated the introduction of vaccine passports for indoor dining must be extended before the 9th of October 2021. You have probably seen reports in the media this week advising that this legislation has been extended to January 2022. To clarify, this is not correct. The Cabinet have agreed to extend this legislation. However, both the Dáil and the Seanad must vote to extend this legislation before the extension actually becomes law. There is much talk that vaccine passports for indoor dining will expire on the 22nd of October 2021, noting, however, that the Minister for Health could reimpose the passports at any time up to January or further if the legislation underpinning this is extended past January 2022. As matters stand, the only businesses legally mandated to implement vaccine passports are indoor dining facilities. However, we have been made aware that an increasing number of businesses without legal mandate are electing to implement vaccine passports as a requirement of admission into their premises or as a requirement for access to their goods or services. To date, we have been advised of the following types of businesses and venues who have required or who are requiring the production of vaccine passports for admission purposes. Access to organ transplant by Beaumont Hospital. Access to indoor canteens by students on college premises. Access to hospitals in the capacity of a visitor. Access to in-person hospital appointments for children where the parents are unvaccinated. Access to indoor child soft play areas unless the parents are vaccinated. Access by players to competitions such as snooker. Access to school information evenings unless the parents are vaccinated. Access by children to foreign school trips unless accompanied by an adult. Access to training courses, access to cinemas and access to concerts. Therefore, should a situation arise whereby the Irish government withdraw the legal mandate for vaccine passports for indoor dining facilities, it is quite likely that private businesses will continue to elect to implement such passports without being legally required to do so. I believe that any such processing of health data represents unnecessary and excessive data collection for which no clear legal basis exists, and therefore I believe that any such processing is illegal. So what can we do? In my view, the strongest position to tackle this heinous invasion of privacy is from a data protection perspective. So the purpose of this video is twofold. 1. To explain why I consider asking for vaccine passports outside of indoor dining to be illegal. And 2. To ask everybody watching this video to issue the 2 template letters, both of which can be found at the link in the description box of this video. The first letter is to be issued to any business asking for vaccine passports outside of indoor dining, and failing a reversal of their policy, the second letter is to issue to the Data Commissioner. The main purpose of this campaign is to encourage the Data Commissioner to publish a guidance paper outlining why these businesses cannot ask for your private medical information as a condition of entry into their premises or in order to access their goods or services. You might be thinking that this is a waste of your time, as the Data Commissioner will not produce such a guidance paper. I believe you are wrong, and in support of my position I say the following. 1. The Data Commissioner received a total of 4,660 complaints from individuals under the General Data Protection Regulations in 2020. So it is conceivable that if we could encourage a minimum of 1,000 people to send in a complaint on this issue within a 2-week period, that this would raise a big red flag within the Data Commissioner's office, and it may prompt them to address this issue at a national level in order that they stop receiving these complaints. And 2. The Data Commissioner has already issued what I would consider to be unhelpful guidance around COVID-19. And when I say unhelpful, I mean unhelpful for the government and anybody else pushing the COVID-19 narrative. The first guidance addressed the fact that there is no lawful basis to undertake temperature checking in the workplace. And the second dealt with the fact that there is no lawful basis, with the exception of frontline healthcare workers, to request the vaccination status of employees in the workplace. Given the Data Commissioner's apparent willingness to address illegalities around the implementation of COVID-19 policies, it is fair to assume that should the Data Commissioner receive a substantial number of complaints regarding domestic vaccine passports, that she may see fit to issue a guidance note on same. The remainder of this video is going to discuss the rights and protections that individuals have around the processing of their private medical information under the General Data Protection Regulations, which came into force in Ireland on the 25th of May 2018. These regulations confirm that everyone has the right to the protection of their personal data, and that personal data must be processed fairly for specified purposes and on the basis of the consent of the person concerned or some other legitimate basis laid down by law. This is the important part. There must be a legitimate basis laid down in law to process your personal data, which includes your vaccination status. So, if a business other than an indoor dining facility requests your vaccination status, which under the regulations is called special category data, they must first determine a legal basis for the processing of such data under Article 6 of the regulations. In circumstances where they can determine a basis under Article 6, the processing of your vaccination status is still illegal unless they can also avail of one of the exemptions under Article 9 of the regulations. It's very important that you understand why asking for your vaccination status is not as easy as some businesses are suggesting or pretending it is, so I will briefly discuss the requirements of Article 6 and 9 of the regulations, because once you understand how these articles operate, you will appreciate the protections that they may offer you, and I hope that this will encourage you to follow up with the businesses who are requesting your data and thereafter follow up with the Data Commissioner. First, we will look at Article 6, which deals with the lawfulness of processing. So, if a business asks for your vaccination status, they can only do so if they can avail of one of the following lawful grounds. 1. The data subject has given consent to the processing of his or her personal data for one or more specified purposes. So, what does consent mean in this context? Recital 32 of the regulations, Conditions for Consent, states, consent should be given by a clear affirmative act establishing a freely given, specific, informed and unambiguous indication of the data subject's agreement to the processing of personal data relating to him or her. Recital 42, Burden of Proof and Requirement for Consent, states, consent should not be regarded as freely given if the data subject has no genuine or free choice or is unable to refuse or withdraw consent without detriment. Recital 43, Freely Given Consent, states, in order to ensure that consent is freely given, consent should not provide a valid legal ground for the processing of personal data in a specific case where there is a clear imbalance between the data subject and the controller. Also, Article 29 Data Protection Working Party Guidelines on Consent under Regulation 2016-670, adopted on the 28th of November 2017, states, generally, consent can only be an appropriate lawful basis if a data subject is offered control and is offered a genuine choice with regard to accepting or declining the terms offered or declining them without detriment. The element free implies real choice and control for data subjects. As a general rule, the GDPR prescribes that if the data subject has no real choice, feels compelled to consent or will endure negative consequences if they do not consent, then consent will not be valid. What this means is that a premises cannot use consent as a lawful basis to request and process your vaccination status if you have no real choice or control over whether you give consent, and if refusing consent would result in you enduring negative consequences, such as being refused admission into the premises. 2. Processing is necessary for the performance of a contract to which the data subject is party, or in order to take steps at the request of the data subject prior to entering into a contract. Article 29 Data Protection Working Party Guidelines on Consent under Regulation 2016-670, adopted on the 28th of November 2017 at Section 3.1.2, Conditionality, states, Article 7.4 seeks to ensure that the purpose of personal data processing is not disguised nor bundled with the provision of a contract of a service for which these personal data are not necessary. According to Opinion 06-2014 of Working Party 29, the term necessary for the performance of a contract needs to be interpreted strictly. The processing must be necessary to fulfil the contract with each individual data subject. This may include, for example, processing the address of a data subject so that goods purchased online can be delivered, or processing credit card details in order to facilitate payment. What this means is that a premises cannot use performance of a contract as a lawful basis to request and process your vaccination status, as this data is not strictly necessary for the performance of the contract, such as attending a concert or a course or a competition. Data that might be considered necessary for a concert could be your name to ensure that you own the ticket you are using to gain admission. In the case of a course, if the course was a CPD course, you might have to provide your name, address, date of birth, qualifications, etc., because this information would be necessary to ensure your CPD points were accurately recorded. 3. Processing is necessary for compliance with the legal obligation to which the controller is subject. As matters stand today, the only premises required by law to impose restrictions upon entry based on a person's vaccination status are relevant indoor premises as set out under the Health Amendment Act No. 2, 2021 or Statutory Instrument 385 of 2021. So the only premises who can rely on a legal obligation as a lawful basis to request and process your vaccination status are pubs, restaurants, cafes, canteens, etc. Only indoor dining facilities. 4. Processing is necessary in order to protect the vital interests of the data subject or of another natural person. The Data Protection Commission Guidance Note, legal basis for processing personal data dated December 2019 states, controllers are most likely to rely on this legal basis where the processing of personal data is needed in order to protect someone's life or mitigate against a serious threat to a person, for example, a child or a missing person. Nevertheless, this legal basis will not apply to all situations concerning the health or treatment of a data subject, but only where the processing is necessary to protect vital interests. What are vital interests? Recital 46 GDPR further elaborates on the kind of situations in which vital interests may apply, namely where it is necessary to protect an interest which is essential for the life of the data subject or that of another natural person, mainly covering life-threatening situations. As such, it is less likely that this legal basis would apply outside of an emergency situation, for instance, where medical care has been planned in advance. It is clear from this guidance that reliance on vital interest is limited to emergency situations to protect a person's life, most often the life of the data subject. Therefore, a premises cannot rely on vital interest as a lawful basis to request and process your vaccination status. 5. Processing is necessary for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller. The Data Protection Commission Guidance Note, legal basis for processing personal data dated December 2019 states, this legal basis is likely to apply to a more limited subset of controllers, where it is necessary for them to process personal data to carry out a task in the public interest or in exercise of their official authority. Article 6.3 GDPR also sets out that where processing is based on this legal basis, it should be grounded on EU or national law which meets an objective or public interest and is proportionate and legitimate to the aim pursued. Thus, a controller may rely on this legal basis if it is necessary for them to process personal data, either in the exercise of an official authority covering public functions and powers as set out in law, or to perform a specific task in the public interest as set out in law. This legal basis is most relevant to public authorities. It is clear from the 2019 guidance that reliance on public task, 1, is intended to apply in the main to public authorities, and 2, can only be utilised where the legal basis is grounded on EU or national law. It is therefore clear that a premises is unlikely to be able to rely on public task as a lawful basis to request and process your vaccination status. 6. Processing is necessary for the purposes of the legitimate interests pursued by the controller or by a third party, except where such interests are overridden by the interests or fundamental rights and freedoms of the data subject, which require protection of personal data, in particular when the data subject is a child. The Data Protection Commission Guidance Note, legal basis for processing personal data dated December 2019 states, as such, legitimate interests is likely to be an appropriate legal basis in cases where controllers process data subjects' personal data in a way which they would reasonably expect and which would have minimal impact on their privacy by virtue of the nature of the processing or safeguards introduced. where there would be more than minimal impact on the data subject's privacy rights or other rights, freedoms or interests, it may still be possible to rely on this legal basis, but the legitimate interest being pursued by the controller would need to be a particularly compelling justification for processing. I think this is the basis that most premises will try to rely on. However, it should be noted that where a premises seeks to rely on legitimate interest basis, such utilisation brings with it heightened obligations to balance the legitimate interest they are seeking to pursue with the rights and interests of the data subject. The data protection guidance goes on to state, where a premises is considering processing personal data based on legitimate interests, they should ensure that they have undertaken a balancing test and be confident that the data subject's interests do not override those legitimate interests and that the personal data are only being used in ways the data subject would reasonably expect, unless there is a very strong reason overriding these concerns. Article 5 of the regulations confirms that where a premises wishes to rely on legitimate interests, they must undertake and keep a record of their assessment to determine whether the legitimate interests were overridden by the interest, rights or freedoms of the data subject. Given that disclosure of vaccination status to enter a premises or to access goods or services is considered by many to be the most intrusive invasion into the privacy rights of citizens in recent memory, it is clear that reliance on legitimate interests would be difficult to justify, given that any justification must be balanced against the fundamental rights of the individual. That concludes a review of Article 6. I hope you can appreciate why it would be difficult for most premises to rely on any of the legal bases set out under Article 6. But let's just assume that they managed to secure one legal basis. This is only the first hurdle they must cross. Subsequent to finding a legal basis under Article 6, they must find an exemption under Article 9 that they can rely on also. Article 9 states that processing special category data is generally prohibited unless the person seeking the data can avail of one of the exemptions under Article 9. The reason for this is because special category data is afforded more protection by the law, not just because this data is more sensitive, but because use of this data could create significant risks to a person's fundamental rights and freedoms and open a person up to discrimination. We will now take a brief look at the Article 9 exemptions, and I will also advise you why I believe it is unlikely that any of these exemptions will apply to the request and processing of your vaccination status by a premises outside of indoor dining. 1. The data subject has given explicit consent to the processing of those personal data for one or more specified purposes. As confirmed earlier, this exemption is not applicable if you do not give free consent. 2. Processing is necessary for the purposes of carrying out the obligations and exercising specific rights of the controller or of the data subject in the field of employment and social security and social protection law insofar as it is authorised by union or member state law or a collective agreement. This exemption is not applicable if your attendance at the premises is unrelated to employment or social security, which it is unlikely to be. 3. Processing is necessary to protect the vital interest of the data subject or of another natural person where the data subject is physically or legally incapable of giving consent. The scope of this exception is limited as it concerns only the protection of vital interests of a person, that is to say, an interest which is essential for his or her life. It includes threats to the physical integrity or life of a person or a third party. In other words, it must be a matter of life and death. The second condition limits drastically the scope of this vital interest exception, as it may only be invoked if the individual is physically or legally incapable of giving consent. This exemption is not applicable as the processing is not essential to life and also in circumstances where you are unlikely to be both physically and legally incapable of giving or refusing consent. 4. Processing is carried out in the course of its legitimate activities with appropriate safeguards by a foundation, association or other not-for-profit body with a political, philosophical, religious or trade union aim and on the condition that the processing relates solely to the members or to former members of the body or to persons who have regular contact with it in connection with its purpose and that the personal data are not disclosed outside of that body without the consent of the data subjects. This exemption is not applicable if the premises is not a foundation, association, or not-for-profit body with a political, philosophical, religious, or trade union aim. Furthermore, even in circumstances where the premises could argue that it is such a body and has such an aim, it should be noted that these organisations may only process special categories of personal data in the course of their legitimate activities. This means that the processing must be directly connected to the political, philosophical, religious, or trade union activities of the organisation. An association or foundation or not-for-profit body cannot invoke this exception to process special categories of personal data that are not closely related to its core activities and in accordance with its purposes and powers set out in its governing charters. 5. Processing relates to personal data which are manifestly made public by the data subject. This exemption is not applicable if you have not manifestly made public the special category data being sought by the premises. 6. Processing is necessary for the establishment, exercise or defence of legal claims or whenever courts are acting in their judicial capacity. This exemption is only applicable where the processing is necessary for legal claims and judicial activities that in many cases require the processing of certain sensitive data. In light of same, this exemption is not applicable and not available to premises. 7. Processing is necessary for reasons of substantial public interest on the basis of union or member state law, which shall be proportionate to the aim pursued, respect the essence of the right to data protection, and provide for suitable and specific measures to safeguard the fundamental rights and interests of the data subject. For this exemption to apply, the premises would need to be able to substantiate that a substantial public interest requires the processing of your vaccination status. I personally think that this would be a difficult case to make because if the processing of your vaccination status were of substantial public interest, it is fair to assume that the government would make disclosure of your vaccination status a precondition of entry into these premises like they did with the indoor dining facilities. Examples of what is considered to be substantial public interest in the UK include the administration of justice to safeguard children at risk, anti-doping in sport, publication of legal decisions. Also, even if a premises can make a case for substantial public interest, this exemption is still not open to them unless the processing is permitted by Irish law, which for the vast majority of premises it will not be. 8. Processing is necessary for the purposes of preventative or occupational medicine, for the assessment of the working capacity of the employee, medical diagnosis, the provision of health or social care, or treatment or the management of health or social care systems, and services on the basis of union or member state law, or pursuant to a contract with a health professional and subject to the conditions and safeguards referred to in paragraph 3. This exemption would only be available to a premises if the processing of your vaccination status is necessary for occupational or preventative medicine or for assessing the working capacity of the employee. So it is fair to say that this exemption would not be available for the likes of attending a course, a concert, or a competition. Also, even if a premises can make a case under this ground, this exemption is still not open to them unless the processing is permitted by Irish law, which for the vast majority of businesses it simply will not be. 9. Processing is necessary for reasons of public interest in the area of public health, such as protecting against serious cross-border threats to health or ensuring high standards of quality and safety of healthcare and of medicinal products or medical devices on the basis of union or member state law, which provides for suitable and specific measures to safeguard the rights and freedoms of the data subject. This exemption is aimed at cross-border threats to health and ensuring high standards of safety of healthcare, medicinal products or medical devices. In my view, it will be difficult to utilise this exemption where borders are not being crossed and in a situation where everyone entering the state must produce their EU Digital Green Certificate, proving their immunity to SARS-CoV-2. Also, even if a premises can make a case under this ground, this exemption is still not open to them unless the processing is permitted by Irish law, which again for the vast majority of premises it will not be. And finally, if a premises wishes to avail of this exemption, they must put in place appropriate measures and safeguards to protect the rights and freedoms of the data subject. It should also be noted that the processing of your vaccination status in this context can only be carried out by a health professional or someone else who owes a legal duty of confidentiality. And 10. Processing is necessary for archiving purposes in the public interest, scientific or historical research purposes, or statistical purposes in accordance with Article 89(1) based on Union or Member State law. This exemption is not applicable as the processing of your special category data is not sought for the purposes of 1. Archiving in the public interest, 2. Scientific or historical research purposes, or 3. Statistical purposes. In conclusion, I believe that we can get many of the businesses and venues who are electing to implement vaccine passports without being legally required to do so to reverse their policies if we apply enough pressure in a consistent and coordinated fashion. The template letter that I am asking you to send to businesses is 15 pages long. It includes a significant amount of research explaining why these businesses have no lawful basis to ask for your vaccination status. As stated earlier, the main purpose of this campaign is to encourage the Data Commissioner to publish a guidance paper outlining why these businesses cannot ask for your private medical information as a condition of entry into their premises or in order to access their goods or services. Please understand that this course of action has a strong possibility of restoring our right to medical privacy in large part, but that your full support will be absolutely critical if we are to achieve this aim. If you wish to partake in this campaign, please see in the description box of this video a link to the ICHR website, which will bring you to our new campaigns page. On this page you will find the information set out in this video, and also at the end of the page you will find 2 links to 2 different letters. The first letter, as set out earlier in this video, is to go directly to the business, and the second letter is to issue to the Data Protection Commissioner in circumstances where you do not receive a positive response from the business. Please support this campaign. Thanks for listening.